What you know, alibis? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Wednesday, May 21st. We are going to recap yesterday's testimony, which would have been day 19. Let's jump right in. Still on the stand, Shanon Burgess from Aperture. The defense is on cross and points out the Commonwealth did not ask him about his supposed education, and the witness did not bring it up either. The defense says a forensic examiner must prioritize accuracy and reliability in the criminal proceeding we're in. Then they move on to the slideshow that shows all of the powering on and off events for Karen's SUV. The witness says all times are correct down to the second. The defense says that none of those are accurate at all and not down to the second. The witness says you're wrong. The defense says all of the relevant events you described in your presentation occurred on January 29th and not January 30th. Your timeline crosses into midnight on January 30th. The witness acknowledges the date is wrong, but says the times are still accurate to the second. The defense says to mitigate the inconsistencies you analyzed yesterday between independent clocks, is your position that forensic methodology recommends cross-referencing timestamps from multiple sources to identify discrepancies and, when possible, leveraging time anchor events that contain both system timestamps and external physical events to identify and correct timing discrepancies? The witness says yes. The defense talks about how they discussed the scientific method and how that's designed to prevent bias from infecting the analysis, and how experts should never selectively gather and interpret evidence to confirm a pre-existing belief while neglecting evidence that contradicts those beliefs. He asked the witness if he agrees, and the witness does. The defense says that's called confirmation bias and it would be improper. The witness says yes. They bring in the witness's January 30th report. You didn't issue an opinion or conclusion regarding the timing of what you called a tech stream event in your January report? No. You did not mention the phrase tech stream event or the backing up event in that report? No. But in that report, you did evaluate the variance between the Lexus Infotainment Center on one hand and John's phone on the other. You compared the call logs on the SUV Infotainment Center to the call logs on John's iPhone to evaluate whether there's a variance. Is it the position, the timestamp call log data, specifically the recorded calls from Karen to John, along with the infotainment power event logs, were analyzed for what you call a clock skew by cross-referencing them against other independent data sources? The witness says no, that would have been comparing the timestamps from the iPhone to the timestamps from the Lexus. They bring in a graph the witness put together comparing timestamps from the infotainment module to John's iPhone. Defense says, despite in your January report of finding discrepancies, you didn't compare the time of the 3-point turn from the infotainment center in the Lexus to John's phone, and the witness says not at that time. Defense, instead, you identified the variance to the calls from the Lexus to John's phone. This data captures an exact moment in time that's easily compared between the two devices. The witness says it does. Defense, according to your own table, there's potential offsets ranging from 1 second, 2 seconds, 8 seconds, 16 seconds, and 21 seconds. And yet you failed to apply this variance to the infotainment time on the Lexus associated with the vent. The witness asked if he could explain, but the defense says the Commonwealth can do that if they choose. Defense says this is simple arithmetic, add or subtraction. And in your initial report on January 30th, you did not take that final analytical step, did you? The witness said the clock variances don't apply to that time frame, but the witness doesn't know what analytical step the defense is talking about. The defense goes on to bring up Dr. Welcher, which is Mr. Burgess's colleague's report, the phone unlock with Face ID, and then the phone lock, which would have been a physical act with the button on the side, is 26 seconds after the trigger event from Dr. Welcher's report. That trigger event is going to be backing up. The witness says that's correct, but it's the unadjusted Lexus clock stamp. The defense also shows Ian Whiffen's report saying that there was a final lock event 26 seconds after the trigger event, which again would have been from physically pressing that lock button. The witness agrees the phone lock would have had to have been done manually. They move on to the steps covering 84 feet at 12:32 and 16 seconds, which is also after the 12:31 and 38 second to 12:31 and 43 second event identified by your colleague, Dr. Welcher, in his slide. The witness agrees. They move on to talk about the pocket state of the iPhone at 12:33 and 14 seconds. The witness did not analyze pocket state detection. Defense, in your January 30th report, you cite only 2 new sources of data before making your conclusion. Correct. They hand him a presentation and say you spent considerable time with this exhibit before you came to court yesterday. And your testimony is this March 5th, 2025 presentation of Dr. DeSogra is the reason you created your May 8th presentation. Another page from the same exhibit he was handed comes in. It's from the defense expert witness who took data points the witness evaluated in his January 30th report. The defense says their expert performed the last step in the witness's analysis. The witness says that his report and Dr. Welcher's also say a lot of data points that do not apply to the time of the accident. The defense asks what he thinks that the defense expert is doing in this chart. The witness says that he's trying to adjust the clock from the Lexus to the iPhone clock, but he does that inaccurately, meaning the defense expert. The defense asks the same question again, and the witness says that the defense expert was trying to adjust time stamps. Defense, do you agree that the methodology of Mr. DeSogra took the last user interaction data points of Dr. Welcher's in his slide and applied the clock variances you put in your January 30th report? No. The witness says the math is correct, but the defense witness is applying incorrect adjustments. Defense, is this the reason you failed to take the final analytical step in your January 30th report is because you knew if you calculated the actual time of the trigger event based upon your own analysis of the clock skew, there'd always be continued interaction on John's phone after the trigger event, and the witness says no. The defense asks about reviewing the 3 timelines from Dr. Welcher, Mr. DeSogra, and Ian Whiffen, all of which establish the trigger event was before that last user activity. And then you decide to issue a new report on May 8th. The witness said he just issued the supplemental report based on the defense expert's report. He looked at Dr. Welcher's, Ian Whiffen's, and DeSogra's report before issuing that May 8th report. And each of those established the trigger event occurred before the last user activity on John's phone. The witness says using either unadjusted timestamps or inaccurately adjusting timestamps. The defense asked if he departed from his January report analysis to the May report to put the trigger event after the last human interaction with the iPhone. The witness said he did not depart from his January report. He clarified his report. The defense says you don't call that a change, you call it a clarification, and the witness says yes. He also said he did not depart from that. He just used another method. The defense says show the jury in your January 30th report you compared the Lexus and iPhone to determine a variance, and call logs are easy to compare. In your May report, you abandon your call log analysis. The witness says no. Defense, you did depart from it. The witness again says he used another method. Defense, you used an approximate time of the 3-point turn as your anchor between the two devices, and the witness says yes. The defense asks, isn't that a classic example of confirmation bias? And the witness says no, it is not. Defense, choosing the 3-point turn as the independent data source is the only way you could get the trigger event to occur after the lock event on John's phone. The witness says it's the only adjustment that can be applied due to the data, but he agrees that's the only way to get the trigger event on John's phone after, and that's the one he chose. The defense says in his report, the witness used the word collision and asked where he got the basis to use that word. The witness said he got it from state police crash reports. Defense, do you state anywhere in your May 8th report that you used those reports at all? Do you list it in your references? And the witness said he did not. The defense points out in a time period of 8 months prior to January 29th, the SUV logged 30 different trigger events, and not every trigger event meant a collision happened. And the witness agrees. The defense says things like hitting the brakes hard, that can cause a trigger event, and the witness agrees. They move on to the analysis that was done by Maggie Gaffney of the Infotainment Center. It gets very, very technical here. It was hard for me to follow, but essentially the witness says a company named Burla produces software that allows for computer systems to be examined while being plugged into the infotainment module. The defense says that new software was not updated at the time of Ms. Gaffney's initial analysis, and the witness agrees. On redirect, the Commonwealth asked the witness when he found out his LinkedIn account was incorrect. The witness said yesterday he created that account years ago, and he does not update it on a regular basis. The witness does not know how Aperture gets the information for their website, and when he submitted his CV to work on this case, he put that he was currently pursuing his bachelor's degree. The Commonwealth asks if a bachelor's degree is necessary to be successful in this field, and the witness says no. He's asked about his mistake regarding megabits and megabytes. The witness said when he realized the mistake, he wrote a supplemental protocol on October 17th. The witness says he was the first one to catch where the missing data was on the computer chip. And regarding the defense expert, he says the Commonwealth did not ask him to do anything. He decided on his own to do further analysis that ended with that May 8th report. Regarding the references the defense witness made in his report, a lot of those were not applicable according to the witness. The defense expert used call logs and GPS data regarding the 3-point turn. But some of the calls by Karen were made outside of her car, which means the SUV clock was not being used. It was actually Karen's phone's clock. He felt this was misleading, and that's when he decided to do more analysis. He says there is a risk if the analyst doesn't consider the source clocks when trying to establish timelines, and the defense expert didn't account for it to sync when describing the trigger event and the phone lock on John's phone. The witness used the 3-point turn as his reference point to synchronize the clocks because it was the event closest in time to that backing up event. Time differences between clocks can vary since clocks are updated by outside sources. Karen's first of the 5 recorded calls to John were made when the SUV was powered off. That meant it was her phone's clock being utilized and not the Lexus. That can result in a 1 or 2 second difference in time. The witness stands by his assessment that the defense witness was incorrect in his adjustments and analysis that John locked his iPhone after the trigger event. The witness saw the defense expert's information on November 7th after He made his own bites and bit mistake. The Commonwealth goes back through the times of these trigger events, and the witness says the difference in time between the SUV and John's phone is anywhere between 21 and 29 seconds. On Recross, the defense asks if he has ever filed anything in court that misrepresented his education. The witness says no. The defense asks about a case in Texas where he was hired as an accident reconstructionist, but in the end did not testify. He is handed a document from federal court, and the defense reads from a court-submitted resume that lists the witness as getting his bachelor's degree in 2024. The witness said the resume was submitted to the court in 2023. Defense says you previously told the Commonwealth you've never submitted a false resume to a court. The witness said this was submitted in 2023 with an expected completion date of 2024. The defense again says the Bachelor of Science in Math and Business Administration does not exist at the University of Alabama, and the witness agrees. The witness says when that resume was filed, he was planning to finish the degree in 2024, but work, family, and life got in the way. And that was it for the witness. He spent a long time on that stand. Moving on, they play a clip where Karen says that they think John died between 12:25 and 12:30. The last witness yesterday was Christina Hanley with the Massachusetts State Crime Lab. She examined the broken glass found at 34 Fairview. She said it had debris on the outside and the inside. She also examined the glass found on the SUV, as well as 9 pieces found at 34 Fairview. She was able to piece together 6 pieces of glass that were found on scene. She could not fit 2 pieces from the bumper to that broken glass. And that was the end of testimony for yesterday. Early this morning, testimony was delayed while the judge wanted to talk to jurors individually, and that was not live streamed. So we're not sure what happened, but I just checked the feed and there is testimony going on. So I will have a recap out for you guys either late tonight or tomorrow. It's going to be a crazy week for me with my daughter's last week of middle school. There's all kinds of ceremonies. So if they're not out the day of, they will be out the next day for sure. Hope you guys have a good rest of your afternoon, and we will see you soon.